Imagine signing up for the Disney Plus streaming service, excited to catch up on your favorite shows and movies. Now, because you clicked agree to the terms and services of their streaming app, Disney could actually prevent you from suing them if something went horribly wrong at one of their theme parks. That sounds absolutely absurd, right? But that's exactly what happened to Jeffrey Piccolo, whose wife tragically died from an allergic reaction at a Disney resort restaurant, only to later discover that Disney could block his right to a jury trial, all because he had previously signed up for Disney Plus, whose terms and services includes an arbitration clause that prevents users from suing Disney for any reason. You might be surprised at the prevalence of these types of forced arbitration clauses and how easily your fundamental constitutional rights can be forfeited away with just a click of a button. For example, if you want to buy concert tickets through Ticketmaster, you will be forced into an arbitration agreement. You want to watch TV through Roku? Well, there's an arbitration agreement hidden in their terms of service. In many cases, buying a car, if something goes wrong, you won't be able to take the manufacturer to court. You'll have to go through secret arbitration. I mean, the examples are literally endless. So to help us unpack all of this, I met up with Tiffany Cianci, an entrepreneur and a small business advocate who has first-hand experience taking on corporations in private arbitration.
The Federal Arbitration Act was an act that was passed with good intentions and actually good practice.
The Federal Arbitration Act, enacted in 1925, was originally designed to encourage the use of arbitration as a quicker and less costly alternative to litigation.
When it was crafted, it was to help corporations that had immense resources work together to seek resolution outside the courts. It was built for things like maritime law specifically. Let's say you have a big shipping company and another big shipping company, and one of them hits the bridge, the key bridge in Baltimore Harbor. And you have very nuanced maritime law. Getting assigned to any random judge, both companies are going to have to spend immense amounts of legal work just educating the judge on the law. If you get assigned to some random judge that doesn't know maritime law, which very few would, okay? So they created the Federal Arbitration Act so that these two large companies on equal footing could choose instead to pay for a judge. They worked together to choose that had the expertise so they could save money legally on educating the judge.
They always make it sound so reasonable at the beginning. Oh, this is just so corporate disputes don't clog up the courts, so they don't have to spend money on silly litigation and instead can pay the workers more. But of course, that's not real life, because over the years and decades, corporations, big and small, have successfully transformed the Federal Arbitration Act into a powerful weapon for forcing arbitration clauses into a wide range of contracts. Commercial contracts, employment contracts, consumer contracts, often to the benefit of the corporation and to the detriment of the consumers and employees.
Corporations have found a way to expand the reach of the Federal Arbitration Act into a position of forced consumer arbitration, forced employment arbitration, forced civil arbitration, forced commercial arbitration. And because of those expansions, which the Supreme Court has continuously upheld, much to the dismay of everyone that is suffering under the weight of it, they've been able to create a circumstance where almost 30% of the cases in the United States that are brought right now are then forced into arbitrations.
Arbitration versus the traditional court system, let's break down the differences. In court, you get assigned a judge for free. In arbitration, you have to pay for a judge.
What you have is a bunch of federal judges and state judges that work, for civil servant money for their whole career. So they'll do their 20 years on the bench or their 15 years on the bench, but their retirement plan is to become an arbitrator. Because as an arbitrator, you don't make civil money anymore. You make whatever you choose. The judge in my case, for instance, charged $27,000 a week. A week. And you have to pay that in advance to be heard.
Another difference. In court, a jury of your peers decides on your case. In arbitration, arbiters, in a lot of cases just one arbiter, often with ties to the corporation, makes the final call.
So if you see your 11 judges and they're immediately going to strike the 3 most affordable ones because they have all the money in the world and they want to force me to a posture of settling, you're immediately going to be forced to strike the ones that are charging $1,200 an hour Because in those cases, you're paying $60,000 a week, right? And who could ever afford that? But here's where it's really bad. The moment that you get assigned a random judge, for instance, I was assigned a random judge. I actually got assigned the one we thought was going to be most favorable of who was left, the most fair. Everybody in the courts in Arizona said he was the most fair. They immediately filed a very expensive objection to that judge. Even though they'd wasted their strikes, they knew about him. They could have struck him, but they didn't. Instead, they spent a very expensive objection saying, we want him struck. And we would have either had to spend a ton of money objecting to their objection and still probably losing, or we had to move to the next one. They did this in every case I've seen them litigate. They've done this to get to the judges they wanted. So they use their strikes to get rid of the affordable ones, and then they just object expensively until they get to the one they want anyway.
It's rigged, right? And you might think that we, the people, are the only ones getting extorted, but oh no. The judges, too, could face extortion, in a sense, if they don't rule the right way.
Now, these big law firms actually have an entire department in each law firm dedicated to knowing the nuances of each arbitrator in their circuits. And so they already know. They have lists of how many times they've won in front of him, whether or not they've showed favorability. They have records of all of their major cases they've ever drafted. But here's where it's really bad. If they cross these big law firms, those departments they're all listed in, add them to a permanent strike list. And every judge knows about these permanent strike lists. So whether they claim to be unbiased or not, they know that they are repeat customers, and I will never be a repeat customer. Their ongoing financial survival depends on not ending up on that strike list. So there cannot be an unbiased situation. It's not possible.
Talk about perverse incentives, right? And in a traditional court system, you can appeal a bad decision. In arbitration, the decision is binding, and appeals are nearly impossible. And the final big difference, the court system provides transparency and public accountability versus arbitration, where everything is a secret. Right in court, at least the public knows what evidence was presented, the arguments on both sides, how the jury ruled, and what the punishment was. Arbitration, on the other hand, most of the time is paired with a confidentiality clause, so the facts about the case are completely hidden from the public.
A lot of people tell me free market, free market, free market. We don't need laws, we don't need regulations. The reality is that when arbitration agreements and confidentiality clauses in these contracts are exploited, there is no free market, because the free market is blind to bad conduct. There's also written in every one of these a non-class agreement, which means you can't combine with other people to bring a class action or a class arbitration. So where in the past, when DuPont was poisoning the water of hundreds of thousands of residents, you got together and you filed a class action or even a class arbitration. Now, you can't do that. The public never finds out about the bad conduct, and there is no free market response to actually rein them in and demand that they hold account. Because in the past, these big lawsuits would have drawn attention, there would have been boycotts, and people would have held them to account and said, if you don't change your ways, we're never coming back. And that would have put them out of business. That doesn't happen. Arbitration agreements are shielding bad conduct, and they've blinded the free market, so there is no free market response.
A 10-year-old boy is recovering after a terrifying fall at a local indoor trampoline park.
In 2019, while riding the Skyrider zipline at an adventure park called Urban Air, a 10-year-old boy suffered a serious brain injury, several broken ribs, and a punctured lung after falling 25 feet onto the concrete surface below. Of course, accidents do happen, but the more disturbing thing about this story is that it was not an isolated incident. Lakeland, Florida, Bloomingdale, Illinois, Newman, Georgia, and many, many others.
Nobody believes that a trampoline park is going to let their kid fall off a zip line. But that's exactly what happened at urban airs all across the United States. They have these iPads you sign your kids in at the front. And when you sign, you're signing them in and you're like, yes, I understand, click, done. Their terms and conditions attached to that quick iPad sign-in are like 94 pages long. And every one of those people had signed that waiver, except for a couple. There were a couple that came with friends of the family, and the friend of the family signed their kid in, and a parent never signed that arbitration agreement. And so those are the only cases proceeding in court.
That's absolutely nuts that The only reason we know about these cases exposing systemic safety issues at a children's adventure park, and the only reason these cases are even allowed to go to trial at all, is because the child's parent had some kind of scheduling conflict or whatever, and they weren't present to sign their kid in.
Most Americans in any given household are bound to as much as 60 arbitration agreements they don't even know they've ever signed. It is so against every ethical standard of what the judicial process is supposed to be to say that you need a lawyer to go to a birthday party, or you need a lawyer to buy a new cell phone, or you need a lawyer to buy a washing machine, or you need a lawyer to buy a ticket from Ticketmaster or Live Nation. These forced arbitration clauses, when you sign in at that trampoline park at Urban Air, you are signing a forced arbitration agreement, a blanket liability waiver. You are signing a non-disparagement clause. It's protecting billionaires at the expense of children, women, families, small businesses, and the disenfranchised.
And so the $1 million question, and in some cases quite literally, because that's how much it's going to cost if you want to hire lawyers and a judge to try to fight for justice in a rigged private court system, is what is the solution to all of this?
Well, the best example of a course to action is HB 5404. That was a federal regulation that passed because of Arizona conduct. Massage Envy had 181, I think it was, women, and I think a couple men that had been sexually assaulted in their franchises, either as employees or as customers. And because their app had an arbitration agreement in it when the women signed in, and because their employment agreement also had an arbitration agreement, they were forcing all of these women into silence after they'd been sexually assaulted. They couldn't go to the press, they couldn't talk to anybody, and they couldn't sue them directly in court. So again, the world couldn't respond. It was through the acts of 3 brave women who violated that clause and went to the press. And it was determined that women who were being sexually harassed and sexually assaulted all across America in employment circumstances, in places like Massage Envy, were being forced into arbitration instead of getting the justice they deserved in a courtroom, that their law was passed that made it so you're no longer allowed to force arbitration in cases of sexual harassment or assault, right? That was one step. But what I believe the best path forward is right now is that there are 18 states in the United States where you can put a voter referendum on the ballot. And the voters can create coalitions to draft laws to put on the ballot and circumvent their legislatures where the lobbyists have control. Now, no matter what, the parties that want to keep everything status quo, protecting billionaires and hurting everyday Americans, they're going to pay for ads and they're going to pay for op-eds and they're going to do all the things, right? But at least you have a chance to get it to the ballot and let voters choose in those states. States like Nevada. Nevada is a great choice where that could be done very effectively. And you need to pay attention to what you sign. And that's not always going to be enough, right? But you can choose to add, if you're presented with an arbitration agreement and they're saying the contract's going to happen with this, say fine. Then I want a clause written in there that says that we both can only use mid-sized firms, no more than 11 attorneys, and that we're not allowed to pay any more than the median attorney wage of a first-year associate in our state, or something like that. You could draft a clause to protect yourself. You shouldn't need a lawyer to go to a birthday party. You shouldn't need a lawyer to rent an apartment. You shouldn't need a lawyer to buy a washer and dryer. But you do right now. And so an educated population and advocating for one another and passing laws is really the only path forward.
That is it for me this week. I want to thank Tiffany Cianci for joining me, giving her time and her knowledge. Everyone should go follow her, and not just follow her. There's actually an action item you can take right now. The FTC is looking for consumer feedback on how corporate consolidations is impacting Americans, and Tiffany has built out a template response form that we can all use to submit and have our voices heard, not just the voices from big business. It's super easy. It takes 3 minutes to do. I'll link that below. If you'd like to support my work, please take a second to hit that like button, share this video with as many people as you can, subscribe if you haven't already done so, hit that notification bell if you so choose. As always, I'd love to thank you for your time. I'll see you in the next one.